And we are back on the 0 Hour. The Supreme Court recently looked at a capital punishment case, and with the deep moral and social implications of capital punishment itself, we want to understand more about it here on the 0 Hour. So joining us now is Diann Rust-Tierney. Diann is the executive director of the National Coalition to Abolish the Death Penalty. She has also served as the director of the American Civil Liberties Union Capital Punishment Project, and she joins us now. Diann, thanks for coming on the program.
Thank you for inviting me.
So, of course, and listen, before we get to this specific case, which is Foster versus Chapman, I just want to make sure that I and our listeners understand a couple things about capital punishment in this country. First of all, capital punishment is only believed to be allowable under our Constitution, because even though our Constitution forbids cruel and unusual punishment, it's been determined by courts that in some way it is not cruel and unusual punishment, which frankly from a moral position I don't fully understand. But let's talk about that for a second. Why do the courts say that capital punishment is not cruel and unusual?
Well, you know, the reality is we've been on a 40-year experiment with regard to the death penalty. The Supreme Court said in a case called Gregg versus Georgia that in theory we could have a system where we could decide people live or die, where there's no discrimination, where it's even-handedly applied, and the worst of the worst get the most of your punishment. But what we've seen over the last 40 years is that theory hasn't been borne out. We have a lot of evidence that people who are innocent are sentenced to death. We have a lot of evidence that geographic disparity affects whether you get a death sentence or not, depending on where you live or in a state or even what state you're in. And, you know, one of the most disturbing aspects of the death penalty is that race is a very real factor when it comes to deciding who lives and who dies.
So I think this is important for people to understand. Thank you for that clear explanation, because, first of all, I'm opposed to the death penalty for a variety of reasons, but I think one of the things that's important for people to understand when we talk about any case like this, particularly a Supreme Court ruling, is that the whole, as I understand it, the legal edifice upon which the death penalty itself is now built requires that it be even-handed, that it not be racially biased, that it not be biased in other ways, that if you get it, you're the worst of the worst, and if you're not the worst of the worst, you don't get it, and outside issues should mean nothing. So I think when we start talking about this particular case, that to me is the context. Now, this particular case of Foster versus Chapman, as I understand it, this is a case where the prosecutors in a death penalty case use their right of preemptory challenge to get rid of, to reject any juror you want to. I guess both sides get a certain number of those to, and correct me if I get this wrong, but to reject any black jurors on a case that I believe involved a black defendant. So first of all, is that correct factually?
Yes, I mean, there's been a long-standing and unfortunate practice in criminal law where prosecutors routinely removed qualified African-American jurors in particular from sitting on a jury with the sort of unjustified and indefensible attitude that an African-American juror, unlike a white juror, would be incapable of rendering a fair decision when the defendant and the juror shared the same race. And so the court has for a very long time been very clear that a juror may not be excluded solely on the basis of race. And what we've been sort of grappling with over the last 40 years is the degree to which that very clear rule would be enforced. And so Foster raised sort of a very extreme example of this practice, and the question is whether or not the Georgia courts were intending to enforce that. And I think what the court did here was to say, yes, this principle must be enforced, and the state Supreme Court is not free to ignore this very clear prohibition against racial discrimination in jury selection.
So what happened was they rejected, using their challenge rights, they rejected every black juror, and the state Supreme Court in Georgia defended that practice, and it went to the Supreme Court, right?
Essentially, the jurors that were struck, there were 4 African American jurors who were qualified to sit as jurors, who were denied the opportunity to be jurors in this case, and the state raised, all these sort of generalized objections to their sitting. But when you really got to and looked at the facts, you found that there was no other explanation except one that was where the government was looking to actually exclude jurors. For example, they went to the trouble of listing all the jurors and highlighting the African American jurors in green, and then the little key on the paper said, that says who the African American jurors are. They had another sheet of paper that had these jurors are absolute no's, and lo and behold, all the African American jurors topped the list. And so it was very, very clear. There was another document that had something that said, there should be no black churches. Nobody who's part of a black church should be on. So it was very, very clear. And I think part of what was sort of frustrating and disturbing to the court was, in the light of all of this, the state's continual kind of reinventing of reasons. They came back and said, well, no, even though there's all these what we would call smoking guns, green highlighted and lists of people with no's, that what we really didn't want this juror to sit because she was too young. And then the court would look back and say, but there were white jurors who who were allowed to be jurors who were the same age or younger. There was another juror that the state struck, arguing, well, he had a son that was the same age as the defendant. And so that's why we struck him, not because of his race, but yet you went back and you looked, and there were jurors who had white jurors who had sons about the same age as well. So I think it was very disturbing. I think one of the things about this case, this is a story about race, but it's also emblematic of the way states are approaching the death penalty. They are approaching the death penalty and this power to decide who lives and who dies without accountability. And, the idea that a state would obfuscate what they're doing and misrepresent, which, and say these things and think that it would pass muster in the face of these documents is an indication of just how arrogant, this power makes states in exercising it. And I think there's some interesting parallels between this and the next level of lack of accountability and the state's assertions that, yes, we want to execute people, but we want to keep secret where we get the drugs that we use. So this Foster case is about the insidious role that race plays, but it's also about the insidious role that this kind of power has on the government and the way the government behaves in relation to the courts. I
think that's a great point. You make a great point. We're talking with Diann Rust-Tierney, who is the executive director of the National Coalition to Abolish the Death Penalty. And, let's talk about those two dimensions of the issue for a second. When you were describing the green line, the green highlighting of the African-American jurors and the changing stories and changing excuses, certainly in terms of the racial dimension of this, it brought to my mind, and no doubt to yours, or I would think to yours, all the different ways in which racist institutional behavior has been excused or attempted to be defended over the decades with shifting excuses, and whether it's a poll tax or whether it's this and that or tests that aren't applied even-handedly or what have you, that this seemed to me same old, that it just seemed to me this is what people do when they're trying to hide their true intentions, and it's sad but unsurprising to see that it's still taking place in 2016. I guess in terms of the abuse of power dimension of it, it's a fascinating question because, and I'd love to get your thoughts on both those, but the notion that is there something about the death penalty per se? Is there something about what happens when the state seeks to take a human life, that almost, and I'm struggling a little bit to put this into words, but that creates temptations or incentives to lead people to the abuse of power. Is there something inherent in the death penalty that kind of corrupts people in this way?
I think it is. I mean, I think, for whether you're religious or not, when you decide that somebody else doesn't deserve to live, you are putting yourself in a godlike position.
Mm-hmm.
And I think with that comes a certain level of belief in your own infallibility and a lack of questioning. So I think at a very high level, it is very easy for all of us to get on our high horse and to see how much better we are than this other human being, and to see how we know what they deserve, but not do enough self-examination. I also think there is an element of the gamesmanship that at the end of the day, particularly when the stakes are high, it becomes about winning and winning at all costs. And for a very long time, this is not a sort of mysterious how we got here. For a very long time, prosecutors were trained that you win cases when you exclude certain people from the jury, and there was a standard list of people: African American jurors, African American women, and they went down the list. And we had a case, where in Pennsylvania we actually had a videotape of a prosecutor training young prosecutors on this, what was thought to be sort of basic trial practice. And so if your real goal is winning and winning at all costs, these things are not going to trouble you. So it wasn't that necessarily that we had it's, at some level the real challenge here, or the real concern, is the banality of the evil here.
Right.
This is how we do our business. So I think the death penalty really heightens that risk.
Yes, it certainly does, and I think that's important to highlight. And just to be clear, what are the Supreme Court ruled on this? Now we don't have a 9-person Supreme Court right now. We have an 8-person Supreme Court. There's a vacancy. What was the split in the vote, and who wrote the majority? What are the implications for the future?
Certainly. So Justice Roberts wrote the opinion for the court. And then Justice Alito wrote a concurring opinion, and then Justice Thomas wrote a dissent. And I think some of the questions that came up, there are always the jurisdictional questions that came up, and the court found that yes, we do have jurisdiction to look at this, and there's the technicalities about when the court can rule on certain things. But the heart of the question was really whether or not the lower court's decision that in the face of all this evidence, whether it was clearly erroneous that there wasn't a racial motivation for the prosecutors eliminating these jurors from the opportunity to serve, and that was the question. The prosecutor, as you said, can exclude people who can't be fair. That's because we want to have a fair and impartial jury, and you look at a number of factors. But you cannot exclude people based on race. And so the court, Justice Roberts basically said, look, it's clearly erroneous when you see these lists, when you see the ever-changing rationale for what they did, when you see that what they say they were doing doesn't line up with what they actually did, and that there were white jurors who served who had the same issues that they said that the black jurors had that made them ineligible. That a decision that said that was clearly erroneous, that this was not based on a racial motivation, was clearly erroneous. And I think that's also part of the story, notwithstanding the fact that the court has said long ago that this practice cannot be countenance, that we can't exclude people based on race. The state courts have been remiss, to put it as nice as possible, in enforcing that law, and that's really at the heart of the story.
Yeah, to me, there are, I guess, in conclusion, there are three disturbing things about it, and three reasons why I'm glad the Supreme Court ruled the way it did. One is that excluding by race, whatever your motivations, it may not be because you hate black people, but whatever your motivations, excluding by race is wrong. Two, the arrogance of trying to cover it up is immoral and wrong. And three, the state court in defending it is wrong. So you guys at your organization, at the National Coalition to Abolish the Death Penalty, you have your hands full because these, I think, are three characteristics of death penalty cases. Where can people go to get more information about the work you do?
Well, you can go to our website, which is ncadp.org. You can join our 90 Million Strong campaign because we know that there are lots of people out there who believe that this is wrong, that the death penalty is wrong, that what it encourages in our leadership and our courts and our people is wrong. And what we're doing is we're bringing those people together. We're bringing people together, and we are standing up and we're getting involved, and we're working state by state to tell policymakers that we don't want the death penalty anymore. And we're also talking to our friends and neighbors and educating them on how really badly this system corrupts our values. And so go to our website, ncadp.org, or 90millionstrong.org, which is where you can sign up to be part of the 90 Million Strong campaign. But get involved and get in touch with us, and we will put you to work.
All right. Well, that sounds good. So thanks so much for joining us, Diann Rust-Tierney of the National Coalition to Abolish the Death Penalty. Thanks for joining us.
Thank you for having me.